Good morning, everybody. We have started this web series to discuss each and every article of the Constitution, highlighting wherever it went wrong. Today, I thought of dilating one more contemporary conflicting issue which may be useful to the public regarding land acquisition for national highways under National Highways Act 1956. The popular belief among the people and legal fraternity is that highway alignments are unalterable. Courts would not interfere with the alignment issues. It is true to some extent. Alignment is a sophisticated scientific engineering process, and the courts are not equipped with such knowledge to discuss the alignments, nor are the people, the petitioners. They are not equipped with such engineering technical skills and knowledge. Though it is true, the higher judiciary, namely the Supreme Court and High Courts, would never refuse to interfere in issues where there is violation of law and malafides. So anybody challenging a national highway alignment has to first look into its legal aspects or malafides. Even if there are malafides, it is very difficult to prove them, and that leads to personal animosities and vengeance. Instead, as lawyers, one should look at legal violations if there are any. For example, whenever the central government considers a national highway alignment, first it has to issue a gazette notification in terms of section 3A clause 1 of National Highways Act 1956. That is only a gazette notification. Such a notification has to be published in the vernacular 2 newspapers by the competent authority for land acquisition. Please understand, the gazette notification is issued by the National Highways, whereas its publication should be done by competent authority for land acquisition. This is contained in section 3A subsection 3. In terms of subsection 3A2, brief particulars of land to be acquired should be given in 3A1 notification. Since this notification or publication is being issued by the national highway authorities, they are failing to provide brief particulars of the lands. Had it been the competent authority for land acquisition, who generally is the revenue divisional officer of that area, it is his bread and butter, land details. He deals with them day in and day out. If that publication is issued by a revenue authority, you could have very easily given the land's details and its owners. Since the publication is issued by the national highway authorities, this serious lapse has taken place. Please consider the very purpose of 3A1 notification is to invite objections for use of the land for intended purposes. Without knowing whether your land is affected or not, if affected to what extent, how can you go and submit your objections to the competent authority? This is unfair. Honorable Supreme Court, in case of Barangore Jute Factory case of 2005, first it was held by the Honorable Calcutta High Court and then confirmed by the Honorable Supreme Court, which stated that a section 3A1 notification without brief particulars of the lands to be acquired, their owner's name, and a map of those lands to be acquired is invalid. But unfortunately, in that case, by the time the Honorable Calcutta High Court has decided, and later, of course, the NHAI went in appeal to the Supreme Court, there also it was confirmed. But by that time, the construction of the road was completed and it has come under use also. Then what is use of giving a judgment stating that section 3A notification was illegal? Considering this fact, because much water has flown under the bridge, the actions of the NHAI were fait accompli. Under those circumstances, the Honorable Calcutta High Court has granted 30% more compensation to the land losers. But it should not become a habit to NHAI to first violate the law, construct the road using government forces, and then come before the judicial forums and say much water has flown under the bridge, or that their actions were fait accompli. etc. It should not become a habit to them. Honorable court should come heavily on them for such violations. Coming to section 3D notification. I told you 3A notification was only intention of the central government to acquire certain lands, and its purpose is to invite objections for use of the land for intended purposes. Whether people object or not, whether they are valid or not, the central government can go ahead and issue section 3D1 notification. It is a declaration of acquisition of lands. Thereafter, the lands are vested in the central government. Again, here it is the government who notifies that it has acquired the lands. But unfortunately, these 3D notifications are being issued by the local competent authority for land acquisition, namely an RDO or the joint collector of the state government. This again is another irregularity. Issue of 3A1 notification by the NHAI authority is an irregularity, and issuance of 3D notification by the competent authority for land acquisition is also an irregularity. It should be given by the central government. Then the next step comes section 3G notification. 3G is an award of compensation. It is done by the competent authority for land acquisition. Regarding the quantum of compensation and the issues involved in them, we will deal with in a separate video. After issuing of 3G award, the landlord has to come forward and accept the compensation. If it is not agreeable to him, he may go in arbitration before the collector under section 3G subsection 5. It's a different story. If he refuses to accept that money, or if there are disputing claims, then such money shall be deposited with the land acquisition officer by the central government, and the land acquisition officer shall decide who is the real owner of the land and pays the compensation. In case of disputes as regards the shares of several people in the land, such things are referred to the principal civil judge of that area. This means if any person wants to dispute the alignment, one should not dispute the alignment alone without any other ground, or on the ground that your valuable land is lost. If not you, some other will lose the land and he also will come to court. As such, courts will not interfere with the pure alignment issues. If there are legal violations or malifieds, then the courts would sure interfere. The same was held by Honorable Supreme Court in Dr. Kushala Shetty case. And of course, that was a brownfield issue. A brownfield is one where an existing highway is expanded. Sometimes disputes may arise as to expand it either on the one side or on both the sides, except that change of alignment is impossible in case of brownfield. In that case, that the Honorable Supreme Court held that courts are not equipped with knowledge and technology to decide on the issues of alignment. This section 3D notification has to be issued within 1 year from the date of publication of 3A1 notification. Otherwise, the notification under section 3A1 expires. It ceases to have any effect. In subsection 4, it was held that courts shall not have jurisdiction over these alignment issues or land acquisition issues for national highways. But however, notwithstanding whatever contained in any law for the time being in force, the powers of the constitutional courts, namely high courts and supreme courts, cannot be restricted. They are always approachable under Article 226 of the Constitution. The only opportunity to challenge the alignment per se is that it is against the fundamental principles of greenfield highways. I told you, brownfield highways are those which are connecting the towns. In olden days, people wanted that their town be connected through a highway. They saw it as service facility. But whereas the vehicular traffic has increased manifold and the size of the vehicles also increased manifold. In view of that, it has become necessary to find out an alternative. The alternative is greenfield highways. The fundamental principle is that greenfield highways must pass in a a little away from towns, and such towns should be connected through spurs. The objective is to achieve speed and safety and formation of new growth areas between towns and the national highways and reduction in cost of land acquisition. If the road is passing through any human habitation or a town, the alignment can be questioned. Except that the chance to question alignment is minimal. Only we have to see whether legal formalities have been observed or not, whether there are any violations or not. In most of the national highway disputes, the petitioners lose their case because when a dispute arises regarding national highways, we look to National Highways Act 1956. It is hardly 15-20 pages act. It only says that the government wants a land, it will publish 3A1 notification. Whatever be the response of the landowners, the government will issue 3D notification and automatically the Kala will pass awards under 3G. Then you have to accept the compensation or it will be kept deposited with the Kala. If the compensation is not agreeable to you, you have to go before the arbitrator who is the collector. Except this, nothing is there. As such, looking at National Highways Act 1956, we are disheartened that we are left with no remedy, no opportunity to question. But this is not the truth. The National Highway Authority is bound by two enactments. One is a manual of land acquisition for national highways under National Highways Act 1956, which states that a stretch under the control of one land acquisition authority, namely the RDO, should be issued in only one single 3A notification as far as possible. And it says that a greenfield highway shall pass a little away from towns to be connected to towns through spurs. And then comes the Environmental Clearance Guidelines 2006, amended by 2010, according to which any highway which connects two or more states, which is more than 30 kilometers in length and 20 meters in width, requiring land acquisition, needs a prior environmental clearance certificate. To avoid this, the NH authorities are bifurcating the stretch into less than 30 kilometers each and arguing that prior ECC is not necessary. But the Honorable Supreme Court, in case of Pandarnathan Govindarajulu case, held that bifurcation of the stretches into less than 30 kilometers to avoid ECC was invalid. These 30 kilometers we have to see the total length from starting point to the end point. There is no use bifurcating the stretches into less than 30 kilometers. These are the legal issues concerning national highway alignments. Thank you. Thank you for watching this video. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments.